You're listening to Audiology. Support our work on Patreon, and be sure to submit your requests for topics in the comments below. Abortion has a complex history in the United States, and for a long time, it was not the hot-button issue it is today. Historically, society focused more on the stigma of unwed pregnancies, and abortions were handled quietly within families. The legality and public perception of abortion have evolved over time, sparking debate among historians and legal experts. In 1821, Connecticut led the way with the first state law against abortion, primarily targeting the use of poisons. From the 1840s, the occurrence of abortions began to rise significantly. The 19th century saw medical professionals largely opposing abortion, partly because of competition between formally educated men and women practicing without a medical degree. Despite opposition, both wealthy individuals sought and received abortion services, often from those unlicensed in the practice, which emerged as one of the first medical specialties. The push for anti-abortion laws gained momentum through the press. James S. Witherspoon, who worked closely with Texas's legal system, points out that before the law specifically prohibited it, 27 out of 37 states in 1868 did not allow abortion after the fetus started moving, known as quickening. By the end of 1883, the majority of states, territories, and even the Kingdom of Hawaii, where abortion was previously common, had laws restricting it. Despite changes, more than 10 states did allow abortions before quickening, but by 1900, every state had enacted laws against abortion. Historically, some considered abortion before quickening as a common law offense. Those involved in an abortion where the mother died could be charged with murder. Common law didn't recognize the right to an abortion when the pregnancy resulted from voluntary actions. The landmark 1973 Roe v. Wade Supreme Court decision argued that the historical criminalization of abortion wasn't deeply rooted in common law, suggesting a shift back to more lenient pre-1820 attitudes toward abortion. The ban on abortion aimed not only to save the fetus, but also to protect the mother's life, deter future abortions, and prevent harm to the mother's future fertility. Rather than targeting women who had abortions, authorities focused on gathering evidence against the providers, responding to juries' reluctance to convict women. In the late 1960s and early 1970s, abortion politics were different from today, with opposition coming from the political left and Democratic Party circles, excluding feminists who largely supported legalization. Views on abortion varied widely within religious communities, with many supporting changes in the law for various reasons, including religious freedom and a belief in minimal government interference. By 1971, elective abortion was accessible in a few states and Washington, D.C., prompting some women to travel for the procedure, though not everyone could afford to do so. Shirley Wheeler's manslaughter charge for abortion in Florida highlighted the legal risks women faced. Her conviction, which was later overturned, saw support from groups like the Playboy Foundation and the Boston Women's Abortion Coalition, illustrating the contentious and evolving landscape of abortion rights in the U.S. Sarah Weddington and Linda Coffey teamed up to tackle a legal battle concerning abortion rights. They initially found a married couple who were interested in being part of the lawsuit after the wife, who could not safely give birth due to a neurochemical disorder, heard Coffey's speech. The lawyers wanted a case that argued abortion was medically necessary, but faced a hurdle as the woman was not pregnant at the time. Weddington mentioned they were on the lookout for a pregnant woman in Texas wanting an abortion to serve as a plaintiff, aiming for a legal strategy that also included having a sympathetic judge on the panel, achievable through filing the case in Dallas. Their search initially came up short. Then, in June 1969, Norma McCorvey, a 21-year-old woman pregnant with her third child, became their potential plaintiff. Despite normally not being able to solicit clients directly, McCorvey's situation fell under an exception for public interest cases. McCorvey, being young, white, and seeking an abortion, was seen as an ideal plaintiff due to her demographics and socioeconomic status. When McCorvey inquired about joining the lawsuit, she was initially unsure about whether abortion should be legal or not. It was explained to her in simple terms that changed her perspective, and she agreed to be represented under the condition she thought she could obtain a legal abortion. McCorvey tried to detach from her pregnancy through substances and eventually gave birth to a daughter who was adopted. The lawsuit filed by Coffey and Weddington, Roe v. Wade, on behalf of McCorvey, referred to as Jane Roe, alongside another case, demonstrated their broader intention to challenge and change abortion laws. They also managed to include a physician undergoing prosecution for performing abortions as part of the suit, strengthening their case. The critical moment came when one of their cases was assigned to a panel, which included a judge they felt might be sympathetic. The three-judge panel ruled unanimously in their favor, declaring the Texas law unconstitutional as it violated the right to privacy. However, they didn't issue an injunction to stop the law's enforcement, which left McCorvey and others still unable to legally obtain an abortion. This decision, while a victory, showed the complexity and the limitations of their legal challenge. The legal battle Roe v. Wade made its way to the Supreme Court in 1970, following appeals from both parties involved. Interestingly, the case retained its original title, Roe v. Wade, instead of switching to Wade v. Roe. The Supreme Court justices decided to hold off on making a decision on Roe, along with another similar case, Doe v. Bolton. They wanted to wait until after they had addressed other cases they deemed important. Among these was Younger v. Harris, which presented complex questions about the court's authority to decide on certain matters. Additionally, the court took on United States v. Vuitch, which challenged a law in the District of Columbia that prohibited abortions unless the mother's life or health was at risk. The justices upheld the law, clarifying that the term health in this context was sufficiently clear and shifted the responsibility of proving the risks to the mother's life or health onto the prosecution, rather than the person performing the abortion. Justice William O. Douglas, however, strongly disagreed with this ruling. In his dissenting opinion, he argued that the rights to privacy within marriage and to decide on the size of one's family, recognized in Griswold v. Connecticut, should apply here as well. Douglas pointed out the complex debate surrounding the issue, including the belief held by many that a fetus should be considered a human being. He questioned whether health could encompass broader considerations like the social stigma of birthing a child out of wedlock, the stress of an unwanted pregnancy, the energy required to raise a child, the financial burden of an additional family member, and potential health risks that might not even come to pass. His arguments prefigured those used 2 years later in Roe v. Wade. Following the decision on Vuitch, the court decided the next day that it was time to hear both Roe and Doe. According to Justice Blackmun, Stewart saw these cases as a natural extension of Younger v. Harris, focusing on whether such issues should be addressed at a federal level rather than just at the state level, sidestepping the broader question of abortion's constitutionality. This procedural take meant that the court wouldn't need factual evidence, witnesses, or a record of facts to review the cases. They scheduled oral arguments for December 13, 1971. However, before these arguments could take place, Justices Hugo Black and John Marshall Harlan II retired. Chief Justice Warren Burger, after consulting with Justices Potter Stewart and Blackmun, decided to proceed with the hearings as planned. As Sarah Weddington stood to present her case, she was unaware of the court's real motives for hearing it. They were more interested in who had the right to hear the case, rather than in changing abortion laws on a large scale. She began by arguing why the court should strike down Texas's abortion law on constitutional grounds. However, Justice Stewart redirected the conversation towards who had the authority to hear the case. Weddington argued that there were no issues with jurisdiction and returned the discussion to the right to an abortion, spending a good 20 to 30 minutes on jurisdictional and procedural matters rather than the constitutional arguments. On the opposing side, Jay Floyd, defending the abortion restrictions, made a poorly received joke at the start of his argument. Addressing the court and facing 2 female attorneys, he attempted humor by saying, "Mr. Chief Justice, and may it please the court." It's an old joke, but when a man argues against 2 beautiful ladies like this, they are going to have the last word. This attempt at humor was not well received, with abortion rights lawyer Margie Pitts Hames recalling that Chief Justice Burger looked as though he was ready to leap from his seat in disapproval. Interestingly, McCorvey, the woman at the center of the case, wasn't present for any of the oral arguments. After Weddington had convinced McCorvey not to pursue an illegal abortion and had her sign an affidavit for the lawsuit, the two did not communicate again until 4 months after the Roe decision was made. Following the initial argument session, Chief Justice Burger assigned Justice Blackmun the task of drafting the court's opinions for both Roe and Doe. Although Justice Douglas suggested to Blackmun that Burger might have had secondary motives for this assignment, Blackmun saw it differently. He recognized that Burger himself couldn't write the opinion due to the contentious nature of abortion and the possibility that his views might not align with the majority. He also considered why none of the other justices were chosen. Douglas's liberal stance was considered too extreme. Brennan faced potential backlash from Catholic groups as the only Catholic on the court. A ruling from Marshall might be misconstrued as being primarily concerning African Americans, and Stewart might not advance the legal boundaries far enough on abortion rights. By the time of the first argument, Justices Black and Harlan had been replaced by William Rehnquist and Lewis F. Powell, Jr., who had not yet become Supreme Court justices. In drafting a preliminary opinion for Roe, Blackmun initially focused on the vagueness of Texas's law, an approach that seemed to resonate with some doctors who were concerned about legal disputes over what constituted life. However, after discussions with his colleagues, he shifted his focus towards privacy rights, bringing his opinion more in line with the views of his more liberal peers. This change in direction was further solidified by the court's ruling in Eisenstadt v. Baird in March 1972, which extended the right to privacy to unmarried individuals. Through internal communications, Blackmun felt confident at one point that all 7 justices were inclined to vote in the majority. Despite this, a later suggestion to re-argue the case raised concerns among the liberal justices, cautious of how the newly seated Justices Rehnquist and Powell would vote. Douglas even threatened to dissent from the re-argument decision, but was eventually convinced to stand down by his colleagues. The case was re-argued on October 11, 1972, with Weddington continuing to represent Jane Roe and Robert C. Flowers taking over for Texas. Adding a twist to the proceedings, a memo from Douglas discussing the case was leaked to and subsequently published in the Washington Post before the court's decision was officially announced. Throughout the summer break, Justice Blackmun diligently continued shaping his opinions for 2 pivotal cases, undeterred by the uncertainty of whether he would be reassigned to pen them. He dedicated a week to delve into the history of abortion at the Mayo Clinic in Minnesota, drawing on his experiences from the 1950s when he worked there. His exploration was a collaborative effort with George Frampton, his 28-year-old law clerk back in Washington. D.C. Frampton leveraged the insights from Lawrence Lader's 1966 book, Abortion, a pivotal work penned by the founding chairman of the organization now known as NARAL Pro-Choice America. Lader's arguments and predictions in the book, emphasizing minimal community opposition to legalized abortion and the potential for a landmark court decision, were reflected in Blackmun's papers with at least 7 citations. Additionally, Blackmun's historical survey referenced Cyril Means's articles, which portrayed the common law tradition in a manner favorable to the Roe case. Despite criticism for lack of credibility and alleged misrepresentation from Roy Lucas's colleague, who had received a memo highlighting Means's unconventional scholarly tactics aimed at winning cases. As the court reconvened for a second round of arguments, Justice Powell advocated for Roe to be the forefront of the abortion cases under review, urging for the Texas law to be overturned on privacy grounds. However, not all justices aligned with Blackmun's views. Justice Byron White refrained from endorsing Blackmun's opinion, and Justice Rehnquist resolved to dissent. In crafting the decision, the justices meticulously debated the trimester framework, with Powell suggesting viability as the pivotal point for state intervention, a stance backed by Thurgood Marshall. Nonetheless, Blackmun, in a memo to his fellow justices, proposed the end of the first trimester as a critical juncture, acknowledging its arbitrariness, yet favoring it for likely garnering more support and providing states with legislative flexibility. This perspective was contrary to those favoring viability as the threshold. Meanwhile, Justice Douglas backed the first trimester benchmark, Justice Stewart sought legislative leeway for states, and William Brennan favored a focus on the safety of the procedure for the mother, steering away from fetal age-based framework. On January 22, 1973, the Supreme Court made a landmark decision, ruling 7-2 in favor of Jane Roe, also known as Norma McCorvey. This ruling established that women in the United States had the fundamental right to choose to have an abortion without facing excessive government restrictions. It declared the Texas abortion ban unconstitutional, alongside a similar law in Georgia, as part of a companion case called Doe v. Bolton. An interesting backstory to the release of this decision was when a Supreme Court clerk, Larry Hammond, shared the decision with a Time reporter under the condition it wouldn't be leaked before its official release. However, Time published the decision before the court did, leading to a significant uproar. Justice Harry Blackmun led the writing of the majority opinion for the court, with 6 other justices aligning with his view. Initially, the court had to tackle the issue of mootness since McCorvey had already given birth by the time the case reached them. Yet, they moved forward, citing an exception for cases that could recur but escape review due to their nature. The core of the court's deliberation centered on the right to privacy. It drew from previous cases that established this right, emphasizing its broad application to include a woman's decision to terminate her pregnancy. However, the court was clear that this right was not absolute, balancing it against the state's interests in protecting both maternal health and potential life. Arguing against allowing abortions only when the mother's life was at risk, the Supreme Court rejected Texas's argument that a fetus should be considered a person under the Constitution. The court admitted the complexity of determining when life begins, acknowledging a lack of consensus among professionals in various fields. To navigate the rights and interests involved, the court devised the trimester framework. This framework allowed no restrictions in the first trimester beyond basic medical requirements. The state's interest grew in the second and third trimesters, permitting more regulation, especially when the fetus reached viability outside the womb, typically in the third trimester. Ultimately, the court struck down Texas's abortion laws as unconstitutional, stating they violated the Due Process Clause of the 14th Amendment by not considering the stage of pregnancy or other significant interests. This case significantly affected the nation's abortion laws and sparked ongoing debate and discussions around the topic. In a recent case, 3 judges who agreed with the main decision shared their personal views through concurring opinions. Justice Potter Stewart voiced his agreement by emphasizing that, although the right to an abortion isn't explicitly mentioned in the Constitution, he believes that the court's decision fits within the broader understanding of the doctrine of substantive due process. This doctrine expands the protection of liberty under the Due Process Clause to include certain fundamental rights, not just procedural ones. Justice Potter Stewart voiced his agreement by emphasizing that although the right to an abortion is not explicitly mentioned in the Constitution, he believes that the court's decision fits within the broader understanding of the doctrine of substantive due process. This doctrine expands the protection of liberty under the Due Process Clause to include certain fundamental rights, not just procedural ones. Justice William O. Douglas also agreed with the court's decision, but suggested a different constitutional basis. He argued that the right to choose an abortion should be considered a fundamental right derived from the Ninth Amendment. This amendment suggests that just because a right is not listed in the Constitution doesn't mean it isn't possessed by the people. Douglas felt this was a more appropriate source than the 14th Amendment's Due Process Clause, which the court used. Chief Justice Warren Burger, while concurring with the main decision, took a slightly different stance. He suggested that it might be acceptable for a state to require the approval of 2 doctors before proceeding with an abortion. He also clarified that he did not see the court's decision as having overly broad implications, contrary to what the dissenting judges believed. Burger emphasized that, in his view, medical standards and professional judgment would naturally limit the number of abortions, a shift from previously where the law imposed strict restrictions. This perspective seems to align with statements from the majority opinion articulated by Justice Blackmun. He highlighted that the decision to proceed with an abortion during the first trimester should lie with the attending physician based on medical judgment, not state regulation. This reflects a belief that patients would typically have personal physicians, a notion that was more common in earlier American history but had evolved by the time of this case. Justices Byron White and William Rehnquist were not in agreement with the court's ruling. In his dissenting opinion, connected to the Roe v. Doe's companion case, Bolton, White made clear his skepticism about the court taking a stand on the moral debate between the rights of pregnant women and the rights of unborn children. He expressed, "I find nothing in the language or history of the Constitution to support the court's judgment. The court essentially creates a new constitutional right for pregnant women, and does so without much explanation or justification, allowing this new right to overturn most of the state laws on abortion. This decision essentially strips away the power of states and their citizens to consider the significance of the life and development of the fetus compared to the potential effects on the woman. While the court may have the power to make this decision, in my opinion, it is an unnecessary and excessive use of its power to review laws." White also believed that the issue of abortion should, for the most part, be decided by the people and through the democratic processes established to guide societal governance. Rehnquist echoed some of White's concerns and criticized the majority's reliance on substantive due process, drawing parallels with the court's discredited decision in the 1905 case of Lochner v. New York. He expanded on White's arguments, pointing out flaws in the court's historical analysis. Rehnquist highlighted that to justify its decision, the court had to assume the 14th Amendment covered a right that seemed completely unknown at the time it was drafted. He noted, as early as 1821, we saw the first state law on abortion being put into place by Connecticut. By 1868, when the 14th Amendment was ratified, there were already 36 laws enacted by states or territories restricting abortion, and 21 of these laws were still in force today. Rehnquist used this history to argue, it is clear there was no question about the legitimacy of these laws when the 14th Amendment came into being. He concluded, it was not the intention of the amendment's drafters to take away the state's authority to legislate on this issue. After the decision was made, it triggered a strong reaction. The Catholic Church did not agree with it at all. Some well-known groups that became very active about the Roe decision were the National Association for the Repeal of Abortion Laws, which later changed its name to the National Abortion Rights Action League in 1973 to echo the court's move to get rid of restrictive laws, and also the National Right to Life Committee. This case was so significant that legal expert Ronald Dworkin called it undoubtedly the best-known case the United States Supreme Court has ever decided. Back in the 1960s and 70s, there was this partnership between the population control folks and those advocating for abortion rights in the United States. It was particularly popular among younger women involved in population control. They teamed up mostly because feminists wanted to share in the popularity of the population control cause. Plus, those pushing for population control believed legal abortion could address the looming population crisis predicted by experts. In 1973, Hugh Moore's Population Crisis Committee and John D. Rockefeller III's Population Council came out in support of abortion rights right after Roe was decided. Before this, support had come from smaller groups like Zero Population Growth, except for Planned Parenthood World Population, which had been advocating for getting rid of abortion laws since 1969. Together, these advocates pointed out the benefits of legal abortion, such as less welfare costs, fewer births out of wedlock, and slower population growth. However, their use of these arguments did not sit well with civil rights leaders and Black Power activists who feared abortion could be used against non-white populations. H. Rap Brown called it black genocide, while Dick Gregory famously said, "My answer to genocide, quite simply, is 8 black kids and another one on the way." After Roe, the population control effort hit some rough patches, losing political favor and becoming a point of division. A significant incident involved the Relf sisters, Minnie Lee, 14, and Alice Lee, 12, who were sterilized without their knowledge or consent by a federally funded clinic in 1973. This led to revelations of 80 more minority women being forcefully sterilized over the next 15 months. This raised alarms that abortions could also be forced on women. At the 1974 World Population Conference in Bucharest, Romania, many developing nations argued against the developed world's focus on population control, suggesting it was a way to sidestep addressing the root causes of underdevelopment. They pushed for a more favorable international economic structure instead. As debates around the political usefulness of population control rhetoric heated up, the abortion rights movement began distancing itself from population control efforts. By 1978, a NARAL handbook had openly criticized population control strategies. Into the 21st century, those supporting Roe have said it's crucial for protecting women's rights, personal freedom, bodily integrity, and privacy. They argue that access to safe abortion and reproductive freedom are core rights. Despite debates on where the right to abortion is rooted in the Constitution, there's a belief that Roe correctly placed it under the 14th Amendment. Many feel that achieving gender equality is linked to women's ability to make decisions about their own bodies. Polls have revealed nuanced views on abortion among Americans. While a majority supports Roe and doesn't want it overturned, perceptions vary on the extent and circumstances under which abortion should be legal. Interestingly, both men and women share similar views on abortion, influenced by attitudes towards motherhood, sexuality, and women's societal roles. Even before Roe was overturned in 2022, there was significant public support for keeping abortion legal in at least some situations. A CNN poll from January 2022 showed 59% of Americans preferred more permissive state laws on abortion if Roe were overturned. However, the overturning of Roe, revealed in a leaked draft and confirmed in June 2022, sparked renewed focus and concern among Democrats and even some Republicans about abortion rights and Roe's popularity. That same month, a lawsuit by the Congregational Door Va Door challenged a new Florida law restricting abortion, arguing it infringed on religious freedom, as Jewish law says that life begins at birth, not at conception, a departure from usual legal challenges based on privacy rights. The Catholic Church strongly opposed the Supreme Court's ruling on abortion. In his diary, Blackmun noted the significant backlash from high-ranking church officials, mentioning abortion backlash, 3 cardinals, Vatican, Rochester wires. 2 prominent figures, John Cardinal Kroll of Philadelphia, who was also the president of the National Conference of Catholic Bishops, and Terence Cardinal Cook of New York, both publicly criticized the decision. Kroll described the ruling as an unspeakable tragedy for this nation, with potentially terrifying consequences, while Cook deemed the decision a horrifying action, expressing concern over the impact on countless unborn children. Despite supporting abortion rights, some critics of Roe v. Wade argue that the decision should have framed abortion as a human rights issue, not just a civil rights issue. By focusing on reproductive justice instead of pro-choice, these advocates highlight the inequalities affecting women's access to abortion service, particularly for those who are non-white, poor, or living in rural areas. They believe abortion should be a guaranteed right, which might even influence the training of obstetricians to support abortion rights. However, in the 1989 case of Webster v. Reproductive Health Services, the Supreme Court ruled there was no affirmative right to elective abortions and that states were not required to fund them. Furthermore, some scholars link the denial of abortion rights to forced motherhood, arguing it violates the 13th Amendment's stance against involuntary servitude. Each year, abortion opponents gather in Washington, D.C. for the March for Life, demonstrating against the Roe v. Wade decision. This event, started by Nellie Gray in 1973, draws hundreds of thousands of participants yearly. Critics of the Roe decision argue it lacks constitutional grounding and believe abortion issues should be resolved through state legislatures rather than the Supreme Court. Following Roe, many states tried to impose various abortion restrictions, leading to a series of Supreme Court cases that shaped the legal landscape around abortion, including upholding certain funding restrictions like the Hyde Amendment in the 1980 Harris v. McRae case. These opposition groups generally argue for the recognition of personhood at conception, suggesting that decisions about abortion should involve more democratic processes. Liberal and feminist legal scholars have shown mixed reactions to the Roe decision. Some feel that although the outcome was correct, the approach taken by Justice Blackmun wasn't the best. They argue that achieving the decision through judicial means doesn't justify the process used. David Garrow pointed out that the decision in Roe and also in Doe v. Bolton was significantly influenced by Justice Blackmun's law clerks, George Frampton and Randall Bezinson. Garrow found their level of involvement exceptional, an early sign of a growing trend where law clerks heavily influence decisions. Edward Lazarus, a later clerk for Justice Blackmun, commented that with prior rulings as reference, clerks like him didn't need as much guidance. However, he acknowledged that there were times when key legal ideas published under Justice Blackmun's name weren't originally conceived by him. Lazarus also noted that relying too much on law clerks is a broader issue within the Supreme Court, affecting its decision-making culture. Justice John Paul Stevens agreed with Roe's decision, but believed it should have focused more on privacy rights. Before becoming a justice, Ruth Bader Ginsburg criticized Roe for overreaching and not being centered on women's rights. Ginsburg later pointed out that her expectation of Roe facilitating Medicaid funding for abortions was mistaken, especially after the Harris v. McRae decision upheld restrictions against such funding. Archibald Cox criticized Roe for lacking principled reasoning, resembling more a set of hospital regulations than a constitutional decision. John Hart Ely, in a Yale Law Journal article, criticized Roe for not connecting with constitutional law, while Lawrence Tribe noted the opaque reasoning behind Roe's judgment. Critics like Alan Dershowitz, Cass Sunstein, Kermit Roosevelt III, Jeffrey Rosen, and Michael Kinsley lamented how Roe bypassed legislative action, which could have built stronger support for abortion rights. Benjamin Wittes and others have voiced concerns over Roe disenfranchising conservatives and noted the ruling's lack of solid constitutional underpinning. Justice Blackmun, reflecting on his role in Roe, had mixed feelings. He emphasized that Roe was a court decision, not solely his. He maintained that the decision was correct on constitutional grounds, despite personal opposition to abortion. Blackmun believed the decision would remain a moral issue, regardless of legal changes. Norma McCorvey, the Jane Roe in Roe v. Wade, had a complicated relationship with the case. Initially, she was an emblem of the pro-choice movement, but she later joined the anti-abortion cause, even attempting to overturn Roe. Towards the end of her life, McCorvey revealed that her anti-abortion stance was, in part, financially motivated, a confession that sparked much discussion. Sarah Weddington, who argued Roe at 26, later served in the Texas House of Representatives and held various legal and educational positions. Reflecting on her role in Roe, she admitted to ethical concerns but believed her actions were for a good cause. In later years, she expressed worry about the future availability of doctors to perform abortions, underscoring the ongoing challenges to Roe's legacy even decades after the decision. Dobbs versus Jackson Women's Health Organization was a court case that challenged a law from Mississippi in 2018. This law stopped abortions after 15 weeks, except in cases of medical emergencies or severe fetal issues. The only abortion clinic in Mississippi opposed this law right after it was passed. They argued that it went against the earlier benchmark of 24 weeks for abortion viability, and federal courts agreed, preventing the state from enforcing this rule. Mississippi didn't back down, though. They took their case to the Supreme Court on June 15, 2020. The Supreme Court agreed to hear it on May 17, 2021, but only focused on one key question: are all bans on abortions before the viability of the fetus unconstitutional? They decided not to discuss two other questions Mississippi had raised. Things took an unexpected turn on May 2, 2022, when Politico published a leaked draft from Justice Samuel Alito, dated February 2022. The draft suggested a major shift, stating, "We hold that Roe and Casey must be overturned. It's time to let elected officials decide on abortion laws." This leak was shocking and controversial because it showed a glimpse into the court's discussions, which are usually confidential. When the final decision came on June 24, 2022, the Supreme Court, with a 6-3 vote, supported Mississippi's law and went even further with a 5-4 vote to overturn Roe and Casey. Justice Alito, similar to the leaked draft, wrote in the official opinion that Roe was profoundly flawed from the beginning and that it only fueled debate and division. The court's decision was based on a historical interpretation, asserting that the Constitution doesn't mention abortion and no such right is implicitly covered by it. However, some historians like Leslie J. Reagan critique this perspective as misleading. On the other side, Justices Stephen Breyer, Elena Kagan, and Sonia Sotomayor expressed strong disagreement. They pointed out that the right to an abortion is connected to other important rights concerning bodily integrity and personal decisions. They warned that if the majority's logic stands, it may put other constitutional rights at risk. This landmark decision, thus, not only upheld Mississippi's law, but also fundamentally changed the established rights to abortion, shifting the decision-making back to state legislators. Presidents' opinions on Roe v. Wade, the landmark Supreme Court decision that legalized abortion across the United States, have traditionally aligned with their political party. Presidents Gerald Ford, Ronald Reagan, George Herbert Walker Bush, George W. Bush, and Donald Trump all expressed opposition to the decision. Notably, George Herbert Walker Bush was initially in favor of abortion rights before he opposed Roe later in his career. President Richard Nixon, who appointed 3 justices who supported Roe and 1 who opposed it, never made public comments about the decision. Early in his career, Jimmy Carter was in favor of legalizing abortion under certain conditions, such as to save the life of the woman in cases of birth defects or in other severe situations. However, as president, he personally disapproved of abortion, but recognized his duty to uphold Roe v. Wade. He sought to reduce the number of abortions and voiced a belief that Jesus Christ would not approve of abortions. In later years, Carter encouraged the Democratic Party to support actions assisting pregnant women and to favor restricting abortions except in situations where the woman's life is at risk or in cases of rape or incest. Bill Clinton and Barack Obama were supporters of Roe. Joe Biden's stance has evolved over time. He voted for a constitutional amendment in 1981 that would allow states the power to overturn Roe, but voted against a similar measure the next year. In his 2007 memoir, Biden wrote about his personal opposition to abortion, but stated he wouldn't impose his views on others. By 2021, he articulated strong support for Roe v. Wade, while also expressing respect for those who oppose it, acknowledging their belief in life beginning at conception. Over the years, there have been numerous federal initiatives concerning Roe v. Wade, including the Women's Health Protection Act and the Freedom of Choice Act, among others. These efforts range from laws aimed at defining and sometimes restricting abortion procedures to acts intended to protect both the unborn and individuals or facilities with conscientious objections to abortion. In light of the Texas Heartbeat Act and the Supreme Court's decision to hear the Dobbs v. Jackson Women's Health Organization case, concerns have been raised about Roe's future. Neil Kumar Katyal, a law professor and former acting United States Solicitor General, suggests that Congress has the power to solidify abortion rights, countering the threat posed by the Mississippi case. However, Thomas Jipping from the Heritage Foundation argued that the Women's Health Protection Act oversteps federal bounds by attempting to dictate how states regulate abortion, drawing opposition during Senate Judiciary Committee hearings back in 2014. At the state level, the story is varied and complex. Following Roe, many states enacted laws to protect healthcare workers who object performing abortions. As of 2011, nearly all states and the District of Columbia allowed certain individuals to opt out of performing abortions or providing related information based on their beliefs. Some states, anticipating a potential overturning of Roe, have enacted laws to safeguard abortion rights, while others have put trigger laws in place that would ban abortions should Roe be overturned. Notably, some pre-1973 anti-abortion statutes could be revived if Roe were reversed. Mississippi's legislation in 2012, aimed at making abortion unfeasible without directly challenging Roe, was blocked by court injunctions due to its requirement that abortion providers have hospital admitting privilege. Similarly, Alabama's Human Life Protection Act of 2019 was designed to provoke a Supreme Court challenge to Roe, but enforcement has been halted by a federal judge. Texas introduced a significant shift with its Heartbeat Act in May 2021, banning most abortions as early as 6 weeks into pregnancy and deputizing private citizens to enforce the law. Though the U.S. Supreme Court initially refused to block the law, it later agreed to review specific legal questions about the law, ultimately allowing certain lawsuits to proceed, but not to directly challenge the law itself. The decision in Roe v. Wade led to a 4.5% drop in births in states where abortion hadn't been allowed before. A study from 2019 predicts that if Roe v. Wade were overturned and abortion on demand were banned in some states, the need to travel farther could prevent between 90,000 to over 140,000 women from getting abortions in the year after the decision is reversed. If a constitutional amendment overturned Roe across all states, we might see an 11% rise in fertility rates, as women wouldn't be able to travel to states where abortion is legal to terminate pregnancies. Legalizing abortion in the U.S. saw more women of childbearing age join the workforce, but fewer older women, who might have previously supported their families financially by caring for grandchildren, chose to work or remained out of the workforce. Since Roe, the risk of death from legal abortions has significantly decreased due to better skills among physicians, advancements in medical technology, and earlier pregnancy terminations. Overturning Roe, however, is anticipated to have negative effects on socioeconomic conditions, increase maternal mortality, and lead to other adverse outcomes. The Donahue-Leavitt hypothesis suggests that legalizing abortion contributed to crime rate reductions. This theory proposes several explanations for how abortion may reduce crime, including a decrease in young males, who are statistically more likely to commit crimes, and the prevention of births in demographics more likely to raise children who would engage in criminal activities. One argument is that women who opt for abortions are doing so to delay childbirth until they can provide a more stable environment, influencing factors like maternal age, education, and income, as well as the use of drugs and alcohol, the presence of a father, and the nature of the pregnancy, wanted versus unwanted. Another intriguing theory, the Roe effect, speculates that widespread access to abortion might lead to a future where abortion rights are restricted or outlawed. The logic behind this is that people who support abortion rights might have fewer children, and since children often share their parents' belief, there could eventually be fewer voters to support abortion rights. However, critics of Donahue and Leavitt's work argue that their methodologies are flawed and have yet to definitively prove a significant link between abortion access and later crime rate. Thanks for watching. Share your thoughts in the comments and subscribe for more content.